Let's begin here. There's been mixed reactions since news broke that former President Jacob Zuma has officially launched a private prosecution against the lead prosecutor in his arms deal trial, Adv Billy Downer and journalist Karyn Maughan. Last year, Zuma opened a criminal case against Downer, accusing him of leaking a medical note from his military doctor to Maughan. Some have lauded this development, saying the former president is well within his rights, while others say this sets a dangerous precedent for media freedom in South Africa. Let's speak now to the Jacob Zuma Foundation Spokesperson, Mzwanele Manyi. Mr. Manyi, thank you so much for your time this evening. I was watching your interview with media and society yesterday, and you say this is not an attack on media freedom, but it doesn't seem to convince those that are concerned here, saying that there is a targeting of journalist Karyn Maughan, and saying that this will also prejudice how the court deals with things in an open, and fair manner. How do you respond?
Yeah, good evening, Bongo, and to your viewership. No, I think for us, we are just law-abiding citizens. We have a law in this country, the NPA Act in this particular instance, and we want to be very clear, as the Jacob Zuma Foundation, we want to be very clear that this case is not about media freedom. If anything, this case is about ethical journalism, as it were, over and above the issue that we're dealing with somebody that has flouted the law. There's a law here called NPA Act, Section 41, subsection 6. This law is very strict. It simply says no person shall make information available to any other person, which information would have been part of what would have been gathered in the investigations, as it were. Now we have a situation here where on the 9th of August 2021, that kind of information was indeed given to any other person which is against the law. That's the issue that we're dealing with here. We are not dealing with Karyn Maughan, we're not dealing with media, we're dealing with information that was given to any other information. Two subsections of that section deal with this thing about any information, about any document, about any item. So you should not give anything to anyone. And also I need to address very quickly this issue of documents being filed and being a public record and what have you. That is all well and good, but what we're dealing with here is not documents that were reported to from a court base. These are documents that were reported to from hand of from the people that were handling this information, the NPA, not from the court files, not from court registrar, not from court anything. These are the privileged documents that were given. In fact, so privileged that they were still even unsigned. They were not even commissioned. That's how privileged they are. In fact, to even make the matters even much more confirm that these were privileged, there's even notes here, or rather in the Billy Downer affidavit, where he makes a point that he emphasized to Karyn that don't go to print yet up until the court resumes, which is the right procedure, which is when she should have gotten this information. But on the 9th of August, we got to know, and the question is, if this information was not handled in a reckless manner, in a manner contrary to what the law is saying, how is it that on the 9th of August, we knew about this information, that it's now out there, and yet the court is only the next day? So indeed, we know that the law has been broken, and we want accused number 1, Billy Downer, accused number 2, Karyn Maughan, to go and answer for themselves in court. So that's what this is about.
I'm going to get to the NPA Act in just a moment, but you say that these were, such important and privileged documents. Could the former president's lawyers not have applied for a special permission by the judge to ensure that these documents, even after being admitted into the public record, do not become subject of any media report at all?
Yeah, you see, this is now part of the red herring. That is an issue from court going forward. That's not what we're dealing with here. We're dealing with what has happened before court, capital B.
Yes.
Before court. And if you have to address your questions on a before court level, then we'll be on the same page. But when you start to talk about post court, we are then just trying to create an obfuscation Don't obfuscate.
It's not
Focus
an
on the issue.
obfuscation, Mr. Manyi. It's not. It's a valid question to say that, for example, as a journalist, and let's say I sit in a courtroom and I get handed documents to say this is what we are going to argue on, but do not report on these just before they are, really put before the judge, and they are now public documents. Then, because this is so privileged, then they say, do not run this, and these are documents that are going to be sealed, will never find the light of day. It means, as a journalist, I can never use those documents again. So I am just asking, not to obfuscate, but a valid question to say, if they were so privileged, couldn't the lawyers then ask for a special permission here?
That's not the issue. The issue is not about, that's perhaps an aggravating issue. The issue here is not about what was in it. The issue is the fact that it was leaked, whatever it was. So the focus is not on the fact that it was medical, this, medical, that. No, that is a secondary issue. It's important, but it's a secondary issue. The primary issue here is that it doesn't matter what it is, because the law does not distinguish. The law does not have a sensitivity scale rate. The law simply says no information. The law says no document. The law says no item. That's what the law says. And I've been saying that, in fact, what media people should do, if they think that this is too stringent, then SANEF and all of you guys in the media perhaps go to Parliament and go for the amendment of this law, because as things stand, the law does not make any exception to say before court, the documents not filed yet, you can still share with journalists so that they can, whatever they want to do with it. That might be ideal, but it's not provided for in the law. And as long as the law does not provide for it, if you are going to provide for it for yourself, you are breaking the law.
So let's stay then with the law, because yesterday there was an issue that was not even addressed as well, and I'm keen to hear your thoughts on this one, because when I look at the NPA Act, for example, in this particular section that you're citing, it talks about really what should happen, and it also needs to happen with the written consent of the NDPP if you're going to be sending these documents to anyone and all of that. And Adrian Basson yesterday arguing that, but this particular section relates to employees of the NPA, and the journalist is not an employee of the NPA. I didn't hear a response on that one.
Yeah, no, look, I think that's what he wants the Act to say. The word employee does not feature anywhere in what we're looking at if you're looking at that Act. But what you'll find there is any person. So for Basson to say his employees, that's a Basson's obfuscation as well. That law in front of you says any person. So that any person is very broad as to what it should be. The court must interpret the law. But right now the law says any person. Now, if a person decides that any person means the employee, then Basson must go and convince the court.
So one of the other things that you argued with Naledi yesterday is that this was, it gave Karyn, an unfair advantage, because these documents should have been given to all journalists and, treated with embargoed like we normally see with other press briefings. I wonder if that had in fact happened and these documents found their way into more journalists than one, would the same matter have been pursued for private prosecution against all those journalists?
No, usually when it's going to be an embargoed debriefing, you make sure that the law is taken care of. There'll be all kinds of permissions. No one is going to be surprised. Everybody is going to know all the right sign-offs would have happened. So the matter would have been regularized. So everybody would know, because then everything would be in good faith and all of that. So that can always be arranged. But once things are done clandestinely, once the public broadcaster like the SABC doesn't get to know, but some other private company gets to know, that on its own is irregular. And the point I made to Naledi yesterday was to say, I'm surprised that SABC is not livid about this, because this is unfair treatment of media, especially national broadcaster, which is the one that has got the biggest footprint, as it were, to then just prioritize one tiny media company that has got a very niche market and what have you. What kind of public interest is this? This is elite interest. It's not even public interest. It's just elite interest. This is elite curiosity. It's not even public interest issue. It's just elite curiosity that needs to be filled and is being elevated to public interest. Public interest would have been accompanied by a public broadcaster.
So, Mr. Manyi, I can ask, though, a different question to that one, to say that, but journalists, work with sources, and the longer you stay with a story, the longer, and, you are exposed to it, and chances of you being the one that gets the documents before anyone else are quite high. And this could have potentially been the case here, because there have been stories that, for example, as a journalist, I've stayed on for too long, and the minute somebody thinks of, giving you information, they give it to you. So how then does that argument hold to say we should all be outraged because we work with sources?
Yeah, I think it's a very good question, but the answer is you must separate where that source is. If your source is public prosecutors of government, then you've got a very dangerous source. If that is your source, because that source is not at liberty to do as he pleases. But if you've got your source as any other Joe soap that's not bound by anything, you can have all the scoops you want. The issue we're dealing with here is not a general scoop. We're dealing with a pure, simple and narrow thing of trying to make sure that we don't have a banana republic. We're trying to make sure that we've got a credible criminal justice system. Now, that's what we're dealing with here. It's not just some scoop for the sake of a scoop. Scoop you can always have, no problem. But once you have a scoop from a government prosecutor, that's serious. You are compromising the criminal justice system. You can't have that.
So how was the former president harmed by this one? Because this was a letter from his lawyers and not his medical records. If you can maybe take us into your confidence here.
Yeah, you see, that again is another obfuscation of an elevated level. The issue here has got nothing to do with President Zuma per se. The issue here is about the law. It's about NPA Act as to why the NPA Act is drafted that way. That's the question that you should ask for those that drafted this NPA Act, as to why they take this so seriously that they say, if you flout this, you are going to jail for 15 years. That you must ask to the lawmakers. This has got nothing to do with President Zuma per se. It does talk to him. As I said, it's aggravating circumstances. But the issue here, the fundamentals here, is unethical behavior all around. That we have unethical behavior from a journalist who goes and gets an irregular information, and unethical behavior from a public prosecutor that gives away information that he should not be disclosing to any other person. So both sides here have got the information, they're dealing with information in a reckless manner, in a prohibited manner, both of them. That's what we're dealing with.
All right, Mr. Manyi, thank you so much for your time. Unfortunately, we have to leave it here, but do appreciate your time. That was Jacob Zuma Foundation Spokesperson, Mzwanele Manyi.